Good morning. This would be my title for presentation today. It is regard to Section 31 of Patent Act 1983 and the opportunity to promote green technology. This is how I'm going to present my presentation. It will be divided into 4 sections: introduction, backgrounds, discussion, and recommendation. The research or the title of the paper is actually concentrates on comparison studies between the provision of Article 27 of TRIPS document and Section 31 of Patent Act 1983. For those who are not familiar with TRIPS, TRIPS refers to agreement. TRIPS refers to agreement on trade-related intellectual properties issues. It's actually the first international patent document that allows countries to refuse or reject a perfectly patentable invention on environmental consideration. Before this, we have this kind of provisions or document, but it's regional in nature. That is in reference to, I'm referring to the European Union Biotechnology Directive 1988. So in terms of Malaysia, Malaysia being a WTO country, we also are required to adopt the provisions of Article 27 into the local law. So when Article 27 of TRIPS is actually translated in the form of Section 31 of Patent Act 1983. But when I make the comparison, there are very few glaring missing terms in the provisions of 31. Even though the missing points are small, but it has a very big effect to the nation and also in terms of the protection of environment. Why? Because I would show you later on, because of these missing terms, we as Malaysia, as a government, miss the opportunity to promote green technology among inventors or industrialists. Okay, let me go back to Article 27 just briefly. Article 27 subsection 1 is actually a minimum standard requirement for all member countries of WTO, whereby Article 27 instructs all countries to award patent to all types of invention. If it satisfies the patentability requirement, then that country is obliged to award patent to that invention. Article 27, subsection 2 is actually an exception to Article 27, subsection 1, whereby even though this invention satisfies the patentability requirement, a state has the right to reject or refuse patent protection. But the rejection must be done on certain grounds only. Why this is allowable? Because Article 27 subsection 2 is actually a filtering system. I call it as a filtering system because it allows government through Patent and Trademark Office to re-evaluate their initial findings, whether they want to finally or eventually go ahead with the patent protection. But like I said just now, the rejection could be done on a non-legal consideration. These are the effects that I mentioned earlier. If we miss Section 31, miss that term, it would actually miss the opportunity to promote green technology and better environment. Okay, this research is actually a qualitative in nature. It was I go through a lot of literature review, referring to documents, for example, the TRIPS document, the EU Directive on Biotechnology Patent 1998 document, because it has some similarities in terms of provision with Article 27 and also Section 31 of Patent Act. And then also judicial decision that is mostly European judicial decisions, because as far as Malaysian patent law is concerned, patent law in Malaysia is still young. There are a lot of provisions whereby we have not judicially decided. So we have to make reference to judicial decision in other jurisdictions who has interpreted this kind of provisions. And then of course I've made some interviews with the lawyers, legal advisors, and using semi-structured question, and also have a focus group discussion with the experts. Why do I choose this qualitative approach? Because it is suitable, because this is actually a new subject matter. Not many research has been done on this topic so far. Okay, here are the wordings, exact wordings of section 27, subsection 1, that I mentioned just now. Patent would be accorded to all invention in all fields of technology if they pass the 3 patentability requirements, namely new, involving inventive step, and also of industrial application. And look at Article 27, subsection 2, which acts as an exception to subsection 1, whereby countries can refuse or reject a perfectly patentable invention from patent on certain grounds. There are 2 major grounds allowable by Article 27, namely to protect order public or morality, including to protect human, animal, plant life or health, or for the purpose of avoiding serious prejudice to the environment. These are actually the exact words of Article 27, which I have segmented to several sections for easy understanding. These are the wordings of Section 31, subsection 1 of Patent Act Malaysia. It is quite simple. And then look at, please pay attention to the words in red, whereby it says that you can refuse patent if the performance of that invention or the commercialization of that invention would be contrary to public order and morality. Okay? So it's quite simple as compared to Article 27.2. These are the highlighted differences, whereby when Article 27 uses the term order public, Section 31 uses the word public order. These 2 words, even though they might look the same, they might sound the same, but they are not actually the same. They have totally different meaning. Order public refers to public policy, which has a bigger ground for rejection, whereas public order is defined as orderly society. It's how the society conducts their life in an orderly manner. So the scope becomes automatically narrower. Okay, have a look also. Article 27 partially defines the meaning of order public and morality. For those who are not familiar with this term, order public is actually a French word. It is originated from the French judicial decisions back about 200 years ago. So we borrowed French word into this legal system. They are to include order public could be, could mean also protection of human, animal or plant life. And Section 31 does not mention or does not define the word morality. So it's up to the courts or to the public to interpret it in any way that they want. So it's not tested yet so far. Okay. The reasons for rejecting patent in Article 27 is made very clear. Whereas this kind of reason is not stated at all anywhere in Section 31 or anywhere in the Patent Act. Okay. Again, as you can see as a comparison, Article 27.2 is a clear-cut policy. You can reject the policy, the objective is that you can reject or refuse a patent to an invention if you, on the ground that you want to promote green and better environment. Whereas, if you look at Section 31, because of the missing terms, the original objective of Patent 1 in original objective of patent law in promoting green technology for better environment, as demanded by Article 27 of TRIPS, is not stated. For that reason, there are big impact on the local scene for Malaysia, because now, due to the missing terms of Section 31, the grounds for refusing and rejecting patent, patent office nowadays, patent office, patent and trademark office may have a very narrow grounds in rejecting patent. They can only reject or refuse patent protection on these 2 grounds only. namely when the invention is contrary to the moral values of the locals, or when the invention is against public order, whereby, meaning when the invention becomes a threat to the orderly life of the society. Morality here is very subjective. It may change according to time, may change according as the knowledge of people progress. The standard of morality also might go down or go up. So again, it's very subjective, and it's not been interpreted or defined anywhere in section 31 so far. So what we can say is that because of this missing term, section 31 could have misinterpreted the original intention of Article 27 of trade. Because of the same reason, section 31 is not able to fully discharge the national obligation in promoting environment. We cannot, the patent office cannot force the industry to produce better technology, because regardless of what type of invention is that, even if it's dangerous to the environment, as long as it satisfies the 3 patentability requirement, it has strong possibility that it would be patented. So that is the real effect, because now I would describe it, taking it as a whole, section 31 is actually without the biting teeth. Section 31 is not able to translate the intention of Article 27 quite correctly at domestic level, and then the section 31 does not really able to act as originally intended as a filtering system or precautionary measures. Because of that, in the end, few inventions might end up being rejected or refused in Malaysia, as compared to maybe in Europe. In Europe or in America, who have followed the Article 27 correctly, you can see the difference that a lot of inventions that are considered might cause danger to the environment would be rejected. As compared to Malaysia, those inventions would be patented. So what we fear is that we don't want Malaysia to become a dumping ground for dangerous invention. And then the another worry is that there are greater potential for most invention to be protected in Malaysia, even though when the invention might cause prejudice to the environment. So in the end of the day, these small overlooked effects might be, very small, but it has a very costly repercussion with irreversible damage. Once damage is done to the environment, it's very costly for us to repair. So I think it's even cheaper to repair section 31 rather than to repair damage done to the environment as a whole. So my recommendation in the end is to actually amend the provision of existing section 31 of Patent Act Malaysia to insert the full terms of Article 27 in the current provision, so that when section 31 is properly termed, it could be the most powerful and effective legal provision in promoting green technology, and in the long run actually educate the society to have a better attitude or a changed attitude towards the protection of environment. Thank you.
Any questions? The audience? Yes. Sorry, I can remember your name. Cynthia from the University of York. Okay. If you could, please, when you ask the question, take the microphone. Thanks.
Yeah, I think that is very interesting what you are putting in about this contradiction in your law. But what is the approach that you are doing? I ignore what is the government system. Are you promoting this to the, I don't know, local regiments to get this to the president, or?
In Malaysia, we exercise, we have this, as a federation country, we have 2-tier government system, federal and the state government. Patent law falls under the federal government's jurisdiction. So in order to amend the provision, section 31 of Patent Act, what we can do is that we need to inform the government that is through the Attorneys General Office, but because they are the one responsible in drafting and also in taking care of the laws in Malaysia, so that they could bring the what we call this recommendation to the parliament, and then they will go through the usual parliamentary processes to be so that the law by the end of the day could be amended. So it actually falls under the jurisdiction of the federal government, not through it could be done either through the federal government bill or the MP's bill. Member of Parliament bill is we go through the politician and ask the politician to bring the matter up to the Parliament. But through the government's bill, it will be slightly easier because we go through the Attorney General's office, and they, on behalf of the government, would do it on behalf of the whole people of Malaysia. Okay, I forgot to mention just now in my, I've written it there, but I did not mention it. This is actually I'm going to propose this kind of amendment to the existing section 31. It would be the third amendment to the law, because the second amendment was done in 1998. So you can see that that is immediately after Malaysia became a member to the WTO organization. We amend our existing intellectual property laws to be aligned to the provisions of TRIPS document. But even then, we missed that one. So after so many years, so this is going to be the third amendment. It is possible. Normally, if you have reasons, if you come up with your data, and then the government would normally follow through. Not that difficult, but it's more difficult in getting to know the people, getting across your idea. The parliament would go through.
Any other question or comment? It's a question, and I mean, I know you missed one opportunity, as you said, but do you have any information on those innovations that should have been rejected, were not, and how many which are the effects of those?
Okay.
Do you have
for example,
that data? Because that could be very interesting to put it on the table and to say.
Okay, there are according to the Patent and Trademark Office, by right, invention that uses the CFC. I don't know. I'm not so good in the CFC technology should be rejected, but because of they passed the patentability requirements, and because of the missing terms of Section 31, the Patent Office has no grounds in rejecting those CFC inventions. Because if you compare it to Europe and America, those inventions has been rejected. And the other one is quite worrying is with the biotechnology inventions, because there are certain inventions which the Patent Office think that might be contrary to the morality of the people of Malaysia, because Malaysia is by majority Muslim country. Because sometimes some of the origins of the gene sometimes in biotechnology invention, the inventor might have extracted a gene from swine, which is actually sensitive to the Muslims. So they feel that they should have, have some more query on this kind of invention. So by right, they shouldn't automatically accord patent, but they cannot.
Very interesting if you could, the number, say, okay, we have this 100 or 10 or whatever patents or inventions that have been patented here, but in Europe, for example, shouldn't have been patented. They should have been rejected. Or if you could say these 5 inventions that have been patented are causing this damage, put that on the table to support your argument. Because, and also, this is just an advice. you could give in the paper more information regarding your methodology. You say you made several interviews, you have a qualitative analysis. Include that on how many interviews with people to kind of first factor interviews or semi-factor interviews. With that information that would be also very, very useful. Okay. Any other questions? Thank you, Nor.